morning and welcome to Employment Law Mid-Year Update and for joining us to learn more about recently published guidelines issued by the Department of Labor and Equal Employment Opportunity Commission related to COVID-19. I'm Sherry Minor McNamara with the Chamber of Commerce, Hawaii. First, mahalo, Torkildson, Katz, Hetherington, Harris, and Knorek, attorneys at law and an Investor Circle member of the Chamber, for providing their expertise and presentations for today's session. It is our honor to partner with Torkildson on the annual employment law updates. They were recently acknowledged by U.S. News and World Report as best lawyers, best law firms, and ranked as Tier 1 in the practice areas of employment law, management, labor law, management, tax litigation, labor and unemployment litigation, and healthcare law. Wow. Congratulations, Torkildson firm. Truly an honor to have you as a member and a partner of this update. Joining us this morning are Director Joseph Ernst and Director John Knorek. Before we get the program started and I turn things over to our panel, I wanted to go over a few housekeeping items. In the interest of time, we will have Q&A at the very end of the presentation. Please feel free to submit questions during any of the presentations by clicking on the Q&A button on the bottom of your toolbar. And for those joining by phone, you can email your questions to Gina Ho at chamberevents@cochawaii.org. Those questions will be reviewed at the end of all presentations. Also, today's webinar is being recorded and the video link, along with copies of the presentations, will be emailed to attendees 1 to 2 business days after the session. Now, before we begin, we are interested in hearing from you on a few poll questions. Poll number 1. The question is, have you returned to in-person work on site? Options are yes, no, I am permanently working remotely. We'll give you a few seconds to make your selections. Okay, Gina, let's share the results. Oh, wow, a majority have returned to in-person work on site. Okay, question number 2. Have you mandated vaccinations? Options are yes, no, still deciding as a company. Alrighty, let's share the results. No, okay, so majority, no. All right, final question. What percentage of your workforce is vaccinated? 0 to 25%, 25 to 50%, 50 to 75, 75 to 100, and we don't have this information. Okay. Don't have this information. Okay, this is good information to have so far. And sorry, it wasn't the final question. This is the final question. Do you offer any paid leave to get vaccinated or recover from any side effects from the vaccinations? Yes, no, and we are considering implementing a program, but have not finalized the details. Okay, let's see the results. Okay, yes, so a majority. Okay, well, thank you so much for participating in the polls. Hopefully this information will provide more info to our presenters and give you insight on those questions, as well as additional information as to how to navigate during this time. So at this time, I'd like to turn it over to John and Joseph.
All right. So I think that I'm going to go ahead and get started because we're still waiting for John to log on so he can come and talk a little bit. But I will start by sharing my screen so we can see the presentation that I have for everyone. So let's do that now. All right, so there we go. Let's see. Okay, so for this part of the mid-year overview, I'm going to kind of go through ARPA, and which, as I think most everyone knows, was just past March 11th, and kind of run through the different parts of it. It is a pretty long act that covers a great deal of things, and certain aspects of these, like the COBRA coverage, premium assistance, is already the subject of standalone presentations. So to the extent that I can cover, the broad overview of it and kind of talk about a little bit of the details, I'm going to do that without monopolizing all of the time to go through that. So I'll try to answer some of your guys' questions about probably the COBRA coverage premium assistance, as that's kind of the big thing from this. But to the extent that I can't, as they mentioned earlier, feel free to put some questions in and we'll try to answer those as we go. Just keep in mind that because this legislation is so new, we don't have a lot of guidance on it yet, and we're still waiting for the DOL and other agencies to kind of weigh in on how things will interplay. All right, so part one, the American Rescue Plan Act of 2021. On March 11th, as I previously mentioned, President Joe Biden signed ARPA. And that bill provides essentially $1.9 trillion in funding, program changes and tax provisions to aid the nation's response and recovery from the coronavirus pandemic. Obviously, that is a lot of money. When I was going through this, it's hard to even imagine $1.9 trillion, let alone seeing how they divide it all up. So, I added in here kind of a breakdown in two different ways so everybody can kind of get a feel for where all of this money is going, because it is such a huge amount of money, right? So the vast majority of it is going to the stimulus checks. So that's 410 billion, 360 billion to government, 246 billion to extended unemployment programs. I think that is important, and we'll cover it a little bit more. I think that a lot of people in the country are still struggling with unemployment and just getting their payments made from, whatever agency is currently holding on to that. I know that even here in the state of Hawaii, we're having a hard time with people that, qualified for the extended unemployment benefits, and they're still not getting any money, or their, payments are being withheld without any kind of explanation, sometimes as far back as September. I heard recently that someone said that, yes, they had applied and were approved, but everything is still pending and they haven't received a check since September. Obviously, that's, all of September, October, November, December, January, February, March. We're 7 months in where this person didn't have a job and was waiting on their payments and hasn't received any money at all. Kind of disturbing that the agency isn't just saying either you've been disqualified, we're not going to give you benefits, or to actually get those benefits out. It's how do people live without those benefits? So then kind of going through to, you'll see that, you got to get all the way up to the very top to, the smallest amount when you start talking about the ERTC and other tax credits that this money is going to go toward trying to benefit. All right, so, we know we asked you guys to do some of the earlier questions about, how much of your workforce has been vaccinated. Are you going to make it mandatory? What are you doing? We took a look at some of the national polls, and we thought that it was interesting to kind of note what was going on. So here, SHRM did a February survey, and it found that 52% of US workers said they would choose to never return to their work site, instead telework permanently if given the option. This number tracks what we are seeing in the mainland. I wasn't necessarily surprised by the responses that we had from you guys about, where things were at with people returning, because, even in our little micro industry of law firms, what we're seeing here locally is that the vast majority of attorneys are back in the office full-time or pretty close to full-time. There are a few holdouts that are kind of doing a blended or hybrid system where it's up to partners whether they want their associates to come in or something like that. But, I think it's probably closer to, 90% are back in the office. Now, contrast that with the mainland, where we're hearing that, 50%, give or take, 60% sometimes, attorneys are saying that they do not want to return to the office full time, and that they will essentially come in when needed, but work remotely. And that was, pretty standard between both partners and associates. So it's not even something where, older workers from different generations may want to be in the office, while younger workers who are used to things like Zoom and FaceTime, and that's kind of part of their everyday life prior to the pandemic, want to stay out. It seems that it's pretty across the board. So, this statistic didn't really surprise me, nor did it surprise me what I'm hearing about, Hawaii workers. All right, so what about people that are out because of illness or injury? Here, again, 2021 survey, 1.5 million people a month missed work in 2020 because of their own illness, injury, medical problems. That is 45% more than usually reported over the past 20 years. Again, from what I was seeing from my clients, my employers, not really a surprise, right? You have a lot of people that are out that either think they might have picked up COVID-19, do have COVID-19, came into contact with somebody with COVID-19, or are scared to come back in for some reason or be in person. So, I hate to kind of put it this way, but I have had a lot of people trying to game the system or abuse the system by saying, oh, I came into contact with somebody with COVID. I can't come into work. I need to be out for 14 days because of it. And then as you try to pump them for information or have them go and take a test, if the company is offering those tests, they don't want to do it, or they're very resistant, or they say, I just want to quarantine and I don't want to do the test. So, I guess the takeaway from this is, yes, a lot more people are out every month during the pandemic, and it's something that we'll likely kind of see continue until we have, either a large portion of the population vaccinated and things a little bit more under control, or, if this kind of drags on longer, then we'll continue to see this trend. All right, so of US employees, how many are going to get the vaccine or not get the vaccine? So again, this is from the SHRM February 2021 survey that they did, and they found that 40% said that they will probably not or definitely not get the COVID-19 vaccine when it becomes available to them. To me, this is kind of a little bit more of a disturbing statistic, because as we try to transition people back into the workforce or into the workplace, it's been a balance between people's fears of coming into contact with someone who has COVID-19 or getting COVID-19. And if, almost half of the workforce is saying that they will not, or, probably not, or will not get the vaccine, that makes it very difficult to kind of control exposure, right? You have half of your employees who could get it, do have it, could pass it to each other. And as we've seen, just because you're vaccinated doesn't mean that you can't get the virus. It just means that you're significantly less likely or won't have as severe effects. So, what do you do with these 40% of your workforce that's just refusing to get the vaccine, especially when they kind of latch on to that being the reason that they don't want to come back in person? That's kind of remains to be seen. So of that 40%, 70% of the 40%, so that's what, probably 26, 28 people, or 28% of the whole 100% will not get the COVID-19 vaccine, even if their employer requires it. So again, that kind of shows how strongly people feel about this, and the fact that this would likely be a problem, right? I mean, in reality, what would happen if the vaccine was mandated? We don't really know. Will people really decline if it means they lose their job? Probably not, maybe not. It's hard to say though, right? A lot of people are very convinced that there's some sort of, underlying problem with this vaccine that is going to significantly harm them. So they're doing everything in their power to not have to take the vaccine. As a kind of a comparator, when it came time for flu shots this year, some of my health centers and other places did have a problem with even the medical professionals getting their flu shots, of all things, and people just have a real knee-jerk reaction to not wanting to be vaccinated for some things. They just feel that the flu vaccine doesn't work well enough, or it's not effective enough, so they refuse to take it. And employees are creative, right? They understand ways to get out of doing this. Even if you don't have a disability that might keep you from taking a vaccine, whether it is the flu shot or COVID-19 vaccine, they default to the other prong that would get you out of doing this stuff, which is, a religious exemption. And I think that John is going to talk about that a little bit more going forward. So I'm not going to spend a lot of time on that right now, but just keep in mind that, employees are pretty smart. They read stuff online. And as employers, it's your job really to understand what they're saying, what exists, and what your response should be. I just attended an EEOC seminar where they talked about COVID-19 vaccinations and whether they should be mandatory per the agency's view, and what those impacts meant, and they took specific time out to show these little ADA cards that people were printing out from the internet that said, I have a disability and you're violating my rights under the law. Here's my card. Failure to do so means you'll be liable for damages, blah, blah, blah. And, they took the time to show those cards and say, look, these cards are not legitimate. They're just some junk that people download off the internet and try to pass off to either employers or businesses, when people come in and don't want to wear masks or, whatever it happens to be. So, you don't need to accept them. You don't need to honor them. They're empty threats. That's something that, it is important for employers to keep track of, because we will see that with employees. I have seen that with employees, bringing in printouts from the internet that appear to actually be for schools, for elementary schools, but they're trying to translate that over into employment. Okay, I'm going to leave that for now, as the later half of the seminar will be more about that. All right, so kind of moving into the other sections of ARPA. So as I mentioned, ARPA has kind of these big, general points that it covers, and one of those is unemployment insurance. And this has kind of extended things out a little bit. And now it's going to be unemployment insurance ending on or before September 6, 2021. So it's been extended. And these are all of the different types of unemployment that ARPA kind of hits, right? So here's kind of a chart that covers each one of those and talks about them in detail. I'm not going to spend a lot of time on this because this is something that you can kind of read and go through, and it shows different tracks of how somebody who is trying to get unemployment would go, right? So usually it would be go on regular unemployment compensation. That exhausts, goes to pandemic emergency unemployment compensation. That exhaust goes to extended benefits, and then pull up pandemic unemployment assistance. So things kind of just, cycle through, and, whether somebody actually obtains those or not is a separate thing. And then over here, you have the second track where somebody who's self-employed, that works a little bit differently for self-employed people. So to the extent that you need to understand that or see how it's changing for employees or people that may be leaving, this is a good way to kind of work your way through what is going on with that unemployment. All right, so now let's turn to kind of the lion's share of what ARPA does, or what the concern for employers is about ARPA, and that would be COBRA, right? So ARPA includes 100% COBRA subsidy for up to 6 months for individuals and their dependent family members who lost health coverage because of involuntary termination or reduction of hours during the pandemic. ARPA provides an extended election period for those who would be eligible to receive the subsidy but did not initially elect COBRA or let COBRA lapse. Compliance with COBRA will be one of the most demanding aspects of ARPA for employers, right? I think that employers already kind of see this, know this, they're worried about this. I've already had 2 or 3 questions from clients about the COBRA provisions in ARPA, which is interesting because 5 days after it passed, right, we're already getting questions about how to implement this. So in reality, what does this mean? So as far as the COBRA subsidy for up to 6 months, that would cover, 100% the cost of whatever COBRA would typically cover pre-ARPA. So if COBRA would cut for your medical benefits, it includes medical, dental, vision, COBRA would cover all 3 of those. And then under ARPA, the 100% subsidy would cover all 3 of those. So it's going to be essentially the same thing as COBRA, it's just extending it. How far back do you have to look for who this is going to cover? It's basically a 6-month look back. starting in April. So it really goes back to individuals who were terminated involuntarily or had a reduction of hours that triggered COBRA all the way back to October 2020, right? Because typically COBRA lasts for 18 months if you elect. So we look back 18 months from the start of this period, which is April 2021. I think I covered that a little bit more in the slides going forward. I just want to make sure I mention it now. Okay. So let's start a little bit too at the beginning of, who's going to be eligible for this COBRA benefit. ARPA terms these people assistance eligible individuals, or AEIs. So when you start looking at the, any information that's talking about COBRA or how this stuff is covered, you're going to see this referred to all the time, AEIs, AEIs. And that's just these people that would be eligible. So, and there's kind of two broad categories, right? So it's individuals and dependent family members with a qualifying event under either COBRA or state continuation, except for those who voluntarily terminate, or gross misconduct. So it's not just voluntary terminations, it's also gross misconduct. They must have lost healthcare coverage as a result of the termination of employment or reduction in hours due to the pandemic, right? So, for example, if, somebody loses their job as a result of the pandemic or during the pandemic, then they would qualify. And their child would qualify if the child had coverage through the parent's medical plan. Now, if the child ages out of that plan before the person loses coverage, then that dependent would no longer qualify as an assistance eligible individual because they lost coverage due to an event other than a COBRA qualifying event, right? They aged out. It wasn't due to the termination. Okay, so the qualifying event occurs on or after November 1st, 2019. Keep in mind that this should really be October 2019 because COBRA kicks in the month following the month that the qualifying event happened. So if somebody is let go end of October, COBRA would start November 1st, so that person would also qualify. So it's best to actually look back to October, even though it's for when COBRA started November 1st going forward. Okay, so this is for individuals who elect COBRA coverage when that event happened, or it also is for people who did not elect, but could possibly have elected through that 18-month period. So I know that that's a little bit confusing, but essentially it's, did somebody elect it? If so, they might be covered under this assistance program here, or if they decline to do it, they're still going to need to receive a notice because they are now given a second opportunity to go ahead and take COBRA, right? Because people decline COBRA for various reasons. They may not be able to afford it anyway, or, whatever else. So if the individual does not have another offer of employment-sponsored coverage or access to Medicare coverage. So this is stuff that would disqualify a person from qualifying under the COBRA assistance program. So if the person would have been entitled to COBRA after they had lost employment, but then they subsequently became covered under a new coverage program under Medicare, then they would be disqualified from receiving this, and they would no longer be an assistance eligible individual. So what's the duration of premium assistance? The subsidy runs from April 1st to September 30th, okay? So it's only, the COBRA subsidy covers any time that someone should be receiving COBRA during April 1st to September 30th. So assuming that somebody's COBRA actually runs out, say end of April, you don't have to pay them a COBRA subsidy for April through September. It would be a 1-month subsidy because that's all that would be covered under COBRA. Right now, and that could extend out, right? So it could be April and May, or could be April, May, June, or it could be April through September. So any portion of that would be covered. The expiration of ordinary COBRA continuation coverage is determined by reference to employees' involuntary termination of employment or reduction of hours, right? So that cuts off the benefit, like I just mentioned. So if the regular expiration occurs end of April, then you only have to pay that April, so 1-month subsidy would be 100%. And then the date that AEI becomes eligible for coverage under another group plan or Medicare, which is what I previously mentioned. Once that happens, it cuts off their ability to have that 100% subsidy paid. So how does the subsidy work? The employer, insurer, or multi-employer plan sponsor will offset the cost through a payroll tax credit against the Section 3111B Medicare tax. Okay, so that means that it's going to either be the employer, in most cases the employer, possibly the insurer, or the multi-employer plan. They will be responsible for paying that 100% of the subsidy. Okay, so it's their job to pay it. It's their job to get this tax credit and get the offset back. Some of the problems with how this will be implemented going forward is what happens if you have someone who pays, the employee pays the COBRA themselves, right, for like April and May, and then they find out that they qualify for this subsidy. What do you do about the April-May payment? Well, you, employer, are going to need to repay that terminated employee those 2 months worth of premiums and then take the credit for that yourself. So it's a mandatory thing. So you must pay, and you must figure out whether people have paid on their own and then reimburse them for that. Okay. The credit includes the entire COBRA premium, including 2% administrative fee. The credit is refundable. So if for whatever reason the credit that you're taking exceeds the amount of Medicare tax that's being paid, you can file to have a payment made to pick up that gap. Well, they'll send you the actual money to make up that gap. Okay. So if the employer's COBRA premium costs for the affected plan participants exceed their medical payroll tax, they file to get direct payment, like I just mentioned. Okay, so what is the process to file for the tax credit? What forms and notices are required? We don't know yet, right? This is forthcoming. The IRS and the DOL plan to release finalized regulations and guidance to clarify tax credit procedures in April, probably end of April. I want to say they need it out by April 26th. It could be a few days after that or before. Hopefully we get them sooner than later. I know that we're saying April 10th would be the day that they should have it out by, but I have read subsequent to even putting this together earlier this week that they were expecting it a little bit later than April 10th. Employers are required to provide notice of the availability of the subsidy, notice of the extended election period for coverage, and notice of the expiration of the subsidy. So hopefully when we get the DOL notice, we'll have a good, model notice that people can just send out. I think that you have to have the notice out within 60 days of this going into effect. So you should plan on having this out by May 2021 to get this notice out. What it does is it extends out the enrollment period for another 60 days from, I think, either April 1st or when they actually receive this notice. So if you want to try to burn that 60 days fast, you'll want to try to put together a model notice from whatever you can find as far as information or what we can provide to you. Get that out as close to April 1st as possible and start burning the time. If it's not really a big deal to you, wait, get the DOL model notice and send it out. There's also going to be a notice for termination of this subsidy that you're going to need to send. Again, we're supposed to get a model notice because what we think should be included is a little bit clunky and doesn't really make sense per the act. So we're hoping to get a little bit more guidance on that. But essentially, you're going to need to send out, I think, about 45 days in advance of that subsidy ending, that the subsidy is ending. Here's the date that it's going to end. Here's who you contact. If you want to continue, here's how you continue. That way, it's giving people a head notice that their subsidy will be ending. Right. So here again is something I just covered. The employers will need to send the notice to eligible individuals within 60 days after April 1st. Upon receipt of the notice, they'll have 60 days for enrollment opportunity. This is going to place a large burden on employers and whoever, multi-plan and insurers to make sure that they get these notices out, because they're going to have to actually audit all of the people that have worked and been terminated for qualifying events from, like I said, about October 2020 all the way through, honestly, the end of September when this subsidy expires, and keep track of that because they are going to need to get this COBRA subsidy. Once we hit that April 1st day and this goes into effect, it shouldn't be that bad to implement. Really what the problem is going to be is tracking down these people that were let go back in October. Where are they? What's their mailing address? Are they paying? Are they contacting you? What do you do to get a hold of these people? This is going to be entirely the employer's problem to deal with. This isn't going to be something that you can shift the employee to contact you by, like, say, putting up a notice on a website and hoping that people see it and come back. You're going to have to show due diligence of sending out things to last known addresses or email addresses or whatever you can do to show that you're complying. All right. I just kind of covered this a little bit. So here's a summary of things, right? What you're going to want to do is identify individuals currently enrolled, and that would be involuntary terminations of employment or reductions in hours. Keep in mind that voluntary terminations or gross misconduct is not a COBRA triggering event. Maybe you guys have kept records of who was issued COBRA notices anyway when they went, and you can go back and just pull all of those and send out this new notice. That would be great. But who knows? And then this is the tricky part too. Those who could enroll if they had not previously declined or terminated, right? That's why really this audit has to be not just people that elected COBRA, but anybody who was involuntarily terminated or reduction in hours. Okay. All right, so I'm going to leave COBRA for a little bit. We're going to kind of talk about new things that ARPA added to FFCRA. And kind of wrap stuff up after that with, I think, PPP and tax credits. So under the FFCRA or under ARPA, what has happened with this? So I think earlier this year, we knew that the government had kind of extended some of the benefits under FFCRA and said, we'll allow you to take voluntary tax credits if you want to extend, family leave, even though it's expired as of December 31st. It was completely voluntary, right? So a lot of employers said, we're not going to continue it. They haven't done so. But if you wanted to, you could. ARPA kind of allows that to continue and has extended things from March, which was the cutoff the government had previously said, through September 30th, right? So while employers are not required to provide any form of paid leave to employees, whether those impacted by COVID-19 or otherwise, they may do so voluntarily. The Act does offer federal tax credits in order to encourage employers to voluntarily offer paid leave, similar to what was required under last year's FFCRA. The federal tax credit was extended through March 31st, as I mentioned, for employers who voluntarily continued, but ARPA is now extending that 6 months more to September 30th, 2021. So the COBRA premiums, this voluntary tax credit for FFCRA type leave, this is all kind of tied to the September 30th, 2021 deadline. Okay, so what is this employer tax credit, right, for paid sick and family leave? Basically, here's some of the things that ARPA modified. Qualified family leave covered wages increased from $10,000 to $12,000 per employee. There's increases in the number of days of paid leave for self-employed from 50 days to 60 days. It expands paid leave credits to COVID-19 vaccinations and wait times for test results or diagnoses. Now, I think that what we're going to see is probably for employers who want to offer this, that's going to kind of be the big one right now, right? Our employer is going to offer some sort of paid leave to have their workforce go out and get vaccinations or be tested or wait for the results of those tests, right? Because what do we want, right? We looked at, are people mandating, are people going to, try to push for their workforce to get these vaccines? And then we also saw how many people don't want to get vaccines. How can we kind of encourage this without violating any laws, right? This might be one of the ways to do it, to say, look, we will give you 2 hours paid leave to go get your COVID-19 vaccination, provided you show us your vaccine card to prove that you actually got it, something like that. I think that John will probably cover this de minimis idea later in the presentation, but we do know that you shouldn't be offering anything more than de minimis incentives to get the vaccine. So this kind of, 1 to 2 hours of paid leave to go do it, voluntary, probably de minimis, probably, right? And ARPA also adds employer restrictions for credits if leave policies favor highly compensated employees, full-time workers, or employees based on tenure, right? What they don't want to see is employers essentially favoring only those people that either make lots of money or have a full-time job, right? A lot of what this is designed to cover are people that are struggling to make things work, right? People with families, with kids, with that are sick, that need to be out. Maybe they just got their job. They don't want to see people losing their job simply because they need to go get a vaccine or go be tested. All right, so turning to PPP loans and an employer tax credit. This will be pretty quick, so we'll kind of go through this as these portions are a little less complicated. But again, you know, ARPA is not the shortest thing, so there is fine detail. So as far as PPP loans, what we had was on March 18th, an interim final rule that was implemented that kind of showed changes to Paycheck Protection Program and, you know, what the coverage is, and the interplay really with the shuttered venue operators grant. So that's really what the focus of this interim final rule was. You know, what happens if someone qualifies for this grant and also is getting either a second draw PPP loan or first draw. And this said, under the final rule, borrowers who receive a first or second draw PPP loan after December 27th, 2020, and have been subsequently approved for an SVO grant will have the SVO grant reduced by the amount of the PPP loan, right? It's just not allowing you to double dip. If a PPP applicant is approved for an SVO grant before the SBA issues a loan number for PPP loan, the applicant is ineligible for the PPP loan, and acceptance of any PPP loan proceeds will be considered an unauthorized use, right? So if you apply for both, you get the SVO grant first. What you're going to need to do is decline and give back the PPP loan. So do not accept that money. If you got the PPP loan prior to getting your SVO loan, then there's going to be an offset that you need to worry about. So it also makes several other clarifications. It includes additional businesses with an NAICS code beginning with 72 that employ no more than 500 employees per physical location. It includes a clarification that electric cooperatives and telephone cooperatives are eligible if they have no more than 300 employees per physical location. There's a clarification that electric cooperatives and telephone cooperatives are no longer permitted to use the employee-based SBA size standard for their industry or SBA's alternative size standard to determine size. It also gives additional details on the types of payroll costs that are not eligible for loan forgiveness. And this, I think, is important enough to kind of tease out a little bit. So what is not going to be eligible for loan forgiveness now? Well, qualified wages taken into account in determining either CARES Act employee retention credit, the ARP employee retention credit, disaster credits, and premiums for COBRA continuation coverage. All right, so what other modifications are there? It maintains eligibility for 501c3 and 501c6 organizations. It expands eligibility to labor organizations, social recreational clubs, and fraternal benefit societies. It also overall increases funding total to roughly $814 billion. So a lot of money. All right, so now let's quickly talk about the employee retention tax credit. So this extends the ERC through December 31st, 2021. It allows eligible employers to claim a credit for paying qualified wages to employees. It expands eligibility to new startups established after February 15th, 2020. It expands eligibility to companies if revenue declined by 90% compared to the same calendar quarter as the previous year. It does cap the credit at $50,000 per calendar quarter for startups. All right, so I know that that was kind of a lot of information, as this, you know, ARPA is kind of a big detailed mess that just went into effect, but I wanted to try to at least cover the basics and focus a little bit on COBRA. Like I said, as I know that that's going to be where the most of the enforcement problems come. And we can talk about a few questions now. Let me double check the time, and then we can kind of turn it over to John to lead the COVID-19 portion of this. It's a little bit more focused. And John, of course, feel free to jump in and talk about whatever you would like.
So we have a few questions on the question and answer thing.
Okay.
Yeah, I'll read them and then you can, if you can answer them. What if someone lost their job in July 2019? COBRA was effective August 2019.
So anything in 2019 is not going to be covered. It's basically an 18-month look back from April 1st, 2021. So it's going to only go back to about roughly an event that happens in October, where COBRA would be triggered November 1st, 2020 forward.
Okay, and then the next question is, employer continues to offer healthcare coverage with co-share premiums. Due to employee non-payment of their share of premium, coverage is canceled. Is employee eligible for a subsidy COBRA, or is it considered voluntary decline of provided benefits, therefore not eligible?
Right. So here, I think that they're going to be eligible under the extended coverage period, that 60-day window, because part of who is considered a qualified individual for these assistants is people who voluntarily declined, but could, but is still in the 18-month window from when that qualifying event happened. So even if you voluntarily decline coverage, you still get a 60-day window to re-enroll and then have whatever portion of that April to September timeframe covered that would be covered under the 18-month period. So I think that they would still get the notice and they would still have the ability to have some partial coverage from that April through September.
Okay, we have a few more questions. We have a policy that after 3 months of leave, not COVID related, a person loses their health benefits and COBRA is offered. Would they also be covered under ARPA?
I think arguably, yes. If COBRA would be triggered, then COBRA is triggered under ARPA. So really all the difference is it doesn't change COBRA itself, really. All it says is that, two things really. You have this 18-month look back in order to figure out who would still be in COBRA had they elected. And then it's, you pay the subsidy from whatever is covered from April through September. So if they qualified before, they probably would qualify now. That, of course, assumes they don't re-qualify for insurance under either another employer plan or Medicare.
But if I understand that, the reason for their leave would have to have been COBRA related, right?
For COVID related, you mean?
Yeah. So I don't know what reason they're on leave for 3 months.
So
if
no, my
if I
understanding,
have a disability, for example, if I have cancer and I'm out for 3 months and my employer has a policy of covering me, Prepaid Healthcare Act would require it anyways. For the 3 months, and at the end of the balance of the month plus 3 months under prepaid healthcare, the company's policy is we stop coverage. If I'm out because of cancer, not COVID related, am I eligible?
my understanding, what I've read, the answer is yes, you are.
Oh, okay.
It does not have to be COVID related for the COBRA portion. It's any COBRA qualifying event.
Okay. To help us out with the correct information to employees, are you providing us with a sample letter that we can send out to our employees?
Not right now. We're waiting on that DOL model policy to come out. We don't have anything yet. I would suggest that you reach out to whoever your counsel is. If that is us, great. If it's not, talk to them about trying to put together a letter based on what we know now to get out April 1st. So I know that's right around the corner, right? It's like 8 days away. You don't have to do it April 1st. You have 60 days. And in that 60 days, we should get the model notice. The only problem with doing that is it extends that 60 days out further. And this is retroactive. So even if somebody elects that didn't elect, if they elect on, say, August 15th, you would need to pay for all of that time period, April through the end, even though they didn't elect until September or August. It's kind of a tricky thing where it's probably best to get something out sooner than later, but you do want to make sure that you include the correct information.
Here's one from Janice, a friend. Does an employee qualify for COBRA premium assistance if they reduce their hours worked by choice versus the employer reducing their hours due to the pandemic?
Boy, that's a good question. I think that would be considered a voluntary, so they probably wouldn't, but did they qualify for COBRA? John, do you know if you voluntarily reduce hours, does COBRA trigger?
I don't know the answer to that off the top.
Yeah, I'll look into that and send a follow-up answer to that to the group. I'll send it to Sherry or Gina, and they'll send it out through Chamber. Because I just don't know that answer off the top of my head. I would think that if it triggered COBRA, pre-ARPA, it would then, yes, ARPA would be triggered. If it did not, then it would not. But I would want to look. I'm not sure about voluntary reduction of hours.
And here's another one. Does the COBRA subsidy apply to workforce consolidation, not due to the pandemic, but due to a company reorganization standardization effort?
Yeah, I think that the answer to that is yes, because everything that I've read so far suggests that it's any COBRA qualifying event. It does not have to be tied to COVID or shown that it was tied to COVID.
So this would likely apply to this. If we have an employee who went out on workers' comp in November and is supposed to be offered COBRA 3/1/21, will this person be covered, even though this is a workers' comp, not pandemic related?
Yeah, I think
Same
the answer
thing.
to that is yes. Yep.
Let me see if there's anything else on here. I think. Oh, here. How do we test that the FFCRA leave is not favorable to HCEs?
What, I don't understand.
I don't either. Maybe this attendee can clarify. How do we test that the FFCRA leave is not favorable to HCEs? Maybe that attendee can clarify. It's an anonymous question, so we'll see if we can get that. Maybe cover it in the second half.
Sure.
So we're running a little ahead of schedule. Do we switch now and go forward and see where we end up? And
yeah, I think that we can switch because there's probably a lot more that we can kind of just talk about when we go through the COVID stuff, because ARPA is so new. There's not a lot of stories or anything to kind of tell, about what we're seeing as a practical matter yet. But with the COVID, I'm sure there's going to be lots of questions about, what do we do for requests for reasonable accommodation, and we can kind of talk about that a little bit more too.
Okay, so now I have to share my screen and see if I can.
And I did see that there was a question about if the vaccine becomes mandated, how would this be applicable to anti-vaxxers? We'll cover that when we go through John's portion of this, because we'll likely cover that. And if not, we'll come back to it at the Q&A at the end.
Okay. Does everybody see the COVID-19 and employment law, pandemic 2? I think this is the right one. I hope it is. It's the one I got from yesterday, okay? So what I'm going to try to cover is how COVID impacts our legal obligations under all the different laws that you see posted there. OSHA, the ADA, Title VII, pregnancy, FMLA, the labor law, NLRA, wage and hour law, plant closing law, Warren. So we're going to cover all these and try to touch on them, some less important than others, and be happy to answer any questions as we move through this. Okay, oops. So here's I guess the kind of issues that we have given the current status of COVID in our community. We're going to address how these laws apply to those people who are currently working, those that are working remotely, those who are still on layoff or furloughed, and then we're going to cover vaccinations and all its various impacts. Oops. Okay, OSHA is about to release more guidance. Everybody is sitting on pins and needles waiting to hear from OSHA what the workplace restrictions and guidelines will be. It was expected to be issued last week or yesterday, and nothing has yet, to my knowledge, been published. Other than OSHA is letting employers know that they're focusing on certain industries to evaluate, particularly, workplaces where employees are working very close together. Obviously, like a meat packing plant, and there's very little of that in Hawaii. But they did add restaurants and food service into the list of potential areas of focus for OSHA going forward. Remember that you're responsible under state and federal OSHA law providing a workplace free of known hazards. And obviously that would include individuals that have COVID. So we have a duty under OSHA to have a policy in place that addresses, I believe, concerns regarding the pandemic. Secondly, employees who complain about workplace safety issues are protected under OSHA. Section 11C of the Act prohibits retaliation against employees for reporting reporting concerns about safety or reporting their own illness. There are protections for employees against actions employers might take that would affect their employment because they're complaining about safety issues or reporting a safety issue or reporting their own illness due to COVID. So what OSHA currently suggests is that an OSHA COVID prevention program that assigns responsibility for the policy to a particular individual in the workplace, a workplace coordinator. Identifies how employees might be exposed to COVID, a policy that identifies a combination of measures that will limit the spread of COVID in the workplace in line with the hierarchy of controls that OSHA and CDC shared. Consideration of protections for workers who are at higher risk of severe illness. And that would be older employees or employees with health conditions that they've reported to the employer that make them more susceptible. Establishment of a system of communicating effectively with workers in a language they understand, obviously, and educate and train workers on your policy. That's the current OSHA guidelines on the kind of policy that you should have. Many employers have already written up policies that detail what their practices will be, mimicking or at least adopting the guidelines that CDC has issued, as well as those from the governor and the mayor's orders on your respective islands. And that generally includes social distancing, mask wearing, the provision of sanitizing, alcohol, and frequent cleaning. Given CDC's recent guidance that those of us who have been vaccinated have an ability to interact more closely with others who have been completely vaccinated, I think that we will see some changes in the local orders as well. Let's see, where are we? Okay. Further guidance, instruct workers who are infected or potentially infected to stay home or isolate and quarantine as necessary. Try to minimize the negative impact of quarantines on workers, isolate workers who show symptoms, perform enhanced cleaning and disinfection, provide guidance on screening and testing, record and report infections and deaths, implement protections from retaliation, make COVID-19 vaccine and vaccination series available at no cost to eligible employees. That's currently the law. And OSHA advises not to distinguish between workers who are vaccinated and those who are not. I think that may be changing in the future, but that's our current guidance from OSHA. Then it says OSHA also provides workers who have or are likely to have COVID-19 should be isolated. And here's the guidelines. If they think or know they had COVID-19 and had symptoms, they can return to work at least 10 days since symptoms first appeared and at least 24 hours with no fever or fever-reducing medications, and other symptoms of COVID are improving, such as loss of taste or smell that could persist for a long time. And B, some workers might need to stay home and isolate longer than 10 days as recommended by their healthcare providers. Workers should quarantine if they've been exposed. This is our last emergency order that I remember, effective April 30th, until April 30th, I'm sorry. Indoor and outdoor social gatherings of more than 10 people are prohibited. Up to 10 individuals may engage in any lawful activity. And as you know, many businesses have essential workers that can be called back to work. OSHA also requires that we report workplace injuries, which include OSHA COVID illnesses that are reasonably related to contact at work. So if there's a confirmed COVID case and it's work related, as you might because they've had contact with a coworker who is positive or other work-related interactions that may created a positive illness. And what you'll find is probably in many of the healthcare industry, as well as emergency responders, those kind of cases are more likely to occur as a workplace illness. Let's see. Okay, a lot of questions have come up as to whether COVID is going to be work compensable. That is, I come to work, I got the sniffles, I have a fever, I say I got to go home, I get tested, I'm positive. Is that a work comp claim? No, usually not. When medical illnesses are broad in the community, such as the flu, or in this case, this virus, the COVID-19, it isn't presumed necessarily to be work related, although in certain circumstances, as I mentioned, it might be. For example, the emergency responders or healthcare workers, or when you know that an employee had contact with somebody who's positive at work and then they report a positive test. If the employee reported being exposed to COVID in the course of doing his or her work, contact your carrier, file a WC1, and make a judgment call on whether you're going to deny liability pending investigation or accept it because you know how the disease was transmitted through a workplace interaction. So here's an example of a case where workers' comp was applied. In a Minnesota case a while back, a woman was traveling through Asia on work, got influenza B. Minnesota ruled that the woman was eligible for workers' comp because she was on a work-related business trip and the disease was not one she would have contacted in the United States. So you try to find some reasonable connection, and if there is some reasonable connection to work activity, it's likely to then be covered by workers' comp. Oops, the image is blocked. Can't. Okay, there we go. So the only other opportunity for an employee who contracts coronavirus to seek damages outside of workers' compensation is if the company behaved recklessly, such as ordering them to China during the virus or sending them into some dangerous place. Workers' compensation law does have an exception for willful or wanton misconduct by individuals. And so if a manager instructs an employee to take their mask off and go into that building where we know there's somebody that's positive, that would likely be willful misconduct that exposed the employee to liability. And if that employee got sick, could sue the manager for willful and wanton misconduct causing their injury. Normally, workers' compensation is the exclusive remedy, except in those kind of situations where there's some willful misconduct. Let's go into the ADA issues. May an ADA covered employer send employees home if they display symptoms? Of course. This is an interesting world. As long as there is a declared pandemic, the EEOC has modified a lot of their rules with regard to questioning employees and taking actions because they have determined by policy that exposure in the workplace to COVID-19 presents a direct threat of harm or illness or injury to other people. And as a result, employers can take steps to prevent that from happening consistent with the ADA. And communications with our Hawaii Civil Rights Commission has indicated that they will follow the same guidelines that EEOC has issued with regard to this information. So yes, you can advise workers to go home if it's not a disability-related action, such as the flu. Can I fire an employee refusing to come to work because of fear of contracting the coronavirus? Yes, if they have an unreasonable fear of contracting the disease and it's not based on either a disability that would make them more prone to illness, and I think that's about it. Oops, excuse me. So let's talk about where we kind of are now in returning to work. Joe, I'm sorry, I got caught up on an emergency call beforehand, so I didn't see any of the responses to our questions. But one of the things that I think everybody's looking at now is returning to work, and how do we return to work? And that kind of goes into the question is when and how. Many businesses have already returned to work. Some are coming back in staggered form. Some are bringing back some employees or alternating days. But as more and more of our population is vaccinated and the numbers stay down, although we had a little spike today, I can see more and more businesses telling employees it's time to come back to the office. So how do you do that? And what can you do consistent with your obligation to maintain a safe workplace and comply with all of the regulations and requirements imposed by state and federal government? Well, the question comes, can you check? Go ahead, Joe. Oh, you had something? Oh, okay. Can I check for symptoms, for example? Yeah. The EEOC has issued pretty detailed guidance that they've updated all year long, all of last year and into this year, that says, yes, employers can ask employees returning to the workplace with other people, have they had any symptoms that are consistent with COVID? And then prevent and tell them then you don't come to work as long as you have symptoms. And they say, well, I got tested for COVID and I'm not negative. I just have the sniffles. Too bad. I can keep you out of work if you display any of the symptoms, even if you've tested negative. So what do you do with that information then? The University of Hawaii, for example, has an app. Other businesses have developed apps that ask employees who are coming onto campus or to check off, do I have any of these symptoms? The EEOC guidance says employees that indicate their medical symptoms of COVID, that information must be kept confidential. And as you know, ADA and state law requires that all medical information about employees be kept in a separate file. So if you're going to collect this kind of information from employees, then you have to maintain it in a confidential manner, and if it's employee specific, in a separate file from their regular personnel information. Can we test? Oh, by the way, the second thing is if I'm teleworking, if I'm working from home and not coming to the office, can I be required to fill out one of these symptoms things? No, it's not relevant to coming to work. So it would be an improper inquiry into their medical condition without objective evidence that the employee has some symptoms. The only reason you can do that for employees returning to the workplace is because the EEOC has determined the pandemic presents a direct threat to other employees if you have symptoms.
Right. I was going to say, I think that's important to note because I know that I've gotten a few questions from employers saying, well, that kind of makes it really difficult for us to deal with because we just want to send this out to everybody and tell them you need to do it every day. And I have employees who come in on Mondays and Wednesdays, but not on Tuesdays, Thursdays, and Fridays. And isn't it easier if I just have them filling it out daily? And the short answer is no, you have to separate it out. If they're going to be in the office or at the job site, then they can fill it out. And if they're not, then they don't need to be doing that, because if they are required to do it, it violates this policy. So you do have to kind of separate it out. And as far as, I get similar questions, right? Well, won't people know and it violate their privacy if somebody comes in to have a check and they're not allowed to come in? Shouldn't we do this in a private place? And, all sorts of questions like that. And, I think that employers are finding creative ways to deal with that. My son's school, we have to do a daily COVID check-in, both for me and for him, because I drop him off in the mornings. And, the way they do it is it's through the app, you answer your questions, and that goes into Magic Cloudland or wherever it goes, where they keep it separate. And then it just displays on the app a green check for him and a green check for me. And then when we get to campus, we show our phones, right? And just, they see the green checks and we go. So it's, you know, it's something that kind of, I guess, keeps the individual questions separated from even the people that are doing the check-in at the school. So I think that, you know, people are developing different ways to implement this. They also do an in-person temperature check.
And the EEOC guidance specifically says that temperature check information is medical information that must be kept confidential pursuant to the ADA and disability law. So if you're doing symptoms checks or temperature checks, recognize that those things have to be kept confidential. And that includes the process by which you do it. Some commentators have said, you know, when you walk into the office and you point a gun at somebody's head and said, okay, 96.5, that is confidential medical information. You're not supposed to be doing it in public. You're supposed to actually train somebody to know how to use that temperature gun correctly, make sure it's calibrated correctly, and that the process by which you do that is in a more confidential manner. So you keep a distance between employees in line, and maybe do it behind a curtain so that nobody else hears what your temperature is. In practice, I've not seen that done, although that's the guidance that many commentators have given the fact that the EEOC says that temperatures are medical information that need to be kept confidential. So, you know, there's going to be a difference between what you see happening in a store when you're a customer, where these regulations don't apply, and what you see in a workplace where an employer is gunning the temperature of their employees reporting to work. There's much greater restrictions on our ability as employers and how we handle that kind of medical information than a store owner who might be wanting to check their customers' temperature.
Right, like, you know, I heard that there were some places that were using like infrared cameras to scan everybody walking through when they come in to see if anybody, you know, appears to be at higher temperature. You know, I don't know how to manage that other than having somebody that's trained to look at whatever the temperature gradients are, and then, you know, pulling whoever looks high to do a separate private, you know, temperature screening. You know, maybe that if we're worried about having to do stuff behind a screen or something, you know, that could be one way to handle it. But even doing that, you're going to have to put up notices that it's happening, right? Or at least with employees, and say, this is the process of how it's going to work. So, you know, I think that we do see creative ways that people are trying to get around it. But I mean, that's also, you know, very expensive, putting up these cameras and monitoring and everything like that.
So another step to protect the workforce is to require COVID testing. And unfortunately, we know COVID testing isn't perfect, but on the other hand, and it's only at that time. So if you have an employee who tests negative for COVID and then goes out partying on the weekend and comes back to work the next week, he might have the illness. So one of the situations you have to think about is it really that helpful to require employees returning to the workplace to get a COVID test? And remember, it's not the antigen test, it's the and the initials escape me, Joe, if you remember what they call it, but the test that's accepted for travel, for example, is okay. But testing just to see if you carry the antigen is not permitted under disability law for employees. And then we can talk about vaccines in a minute. I'm gonna get into that, but let's move into one other thing that you might want to do is travel. Oops, excuse me. Here, sorry. Can you ask employees who are coming back from a leave of absence if they've been traveling anywhere? Oops, for some reason that didn't happen. Oh, Joe, I don't know what happened here.
Well,
there it is.
There you go.
Okay. So can you ask employees who return from vacation if they've traveled? Yes, you can. And can you quarantine them? Yes. If state law says you can quarantine them or they should be quarantined, you can. Let's say state law changes and it says if you've been vaccinated, you don't have to quarantine when you travel. Can an employer impose an extra length of time on you? Because I just want to be sure that after you come back, you're not positive. Yeah, you can. Can an employer deny employees vacation time if they're going to travel out of state during a pandemic? Yeah, probably can. I mean, if you have a collective bargaining agreement and there are union obligations, you might be restricted in doing so under the terms of a collective bargaining agreement. But if you want to establish a policy that says, I don't want my employees traveling out of state or off island or to particular regions where there's a high incidence of COVID, and tell them we're not going to let you use vacation leave if you're going to Miami, Florida, or I don't know where else, New Jersey. Someplace in New Jersey is really high right now. So if you go, or Texas where they don't require mask, we won't allow you to travel to any state that doesn't impose mask wearing or social distancing. You might be able to adopt that kind of a policy if you wanted to. I'm not suggesting you have to or even should, but I know of some businesses that wanted to do that to help. Another issue comes up is what if an employee doesn't follow the proper protocols outside of the workplace? So let's say you have an employee that while they're at work, they wear their mask, but or they posted on Facebook pictures of them at a party not wearing a mask with a whole bunch of other people, clearly in violation of whatever the CDC guidelines and our state and county requirements are for social distancing. What action, if any, can you take against that employee? I believe that you could possibly discipline that employee or terminate them for engaging in conduct that is unsafe and presents a risk to your employees by their off-duty conduct that's creating a dangerous situation. You could be able to discipline them. I would highly encourage that you adopt a policy that tells employees that you expect them to comply with CDC guidelines and the social distancing requirements imposed by state and county proclamations and orders, and that if they fail to do so, they're presenting a risk to their coworkers and will be subject to discipline up to and including termination.
Yeah, I kind of view that similar to the drug testing or alcohol policies that exist that say that you shouldn't be doing drugs outside of the workplace either. And if you're seen doing that, then you could be disciplined. Courts are kind of split on that, whether they'll allow you to enforce it or not. So we typically say probably a bad idea to try to enforce it. But in this case, I think that the fact that that conduct could translate directly into consequences to other employees in the workforce makes it much stronger in enforcing that kind of policy if you have the written policy, right? Doing drugs outside at a party on a Friday night and then showing up to work on a Monday is probably not endangering everyone at work, right? It's just damaging the reputation of the company. But saying, okay, well, you going to, a huge gathering, not wearing a mask, doing whatever outside of CDC guidance, that could directly translate into, transmitting COVID, and you may not even know you have it yet, right? Because you have an incubation period. So I think that, there probably is a much stronger argument looking at it, especially considering some courts do allow you to say simply doing drugs or something that would damage the reputation of the company is enough to discipline someone.
Yeah. And there is some precedent on the travel restrictions that I was mentioning. Let's see if I can get there. Something happened to the slide deck that there it is. Back in 2019, there was a case when Ebola was raging, where a massage therapist in Florida wanted to go back to West Africa for a family event. And the employer said, we don't want you going to an area where there's an outbreak of Ebola, because when you come back, you could be a danger to our customers and coworkers. The employee did that anyway, and they fired her. And then the court said that was appropriate and not a violation of the ADA or discrimination laws, and said even construing the statute broadly, the terms of the ADA protect persons who experience discrimination because of a current, past, or perceived disability, not because of a potential future disability that a healthy person may experience later. So they said the ADA didn't apply to the therapist who was fired for traveling to a dangerous area. And to me, that supports the kind of travel bans some employers in Hawaii have adopted or tried to control. Okay.
Yeah, but again, kind of be careful. This kind of reminds me back to March, April, when we were talking about this a lot, where they wanted to just ban travel to like China or to Asia or to the Philippines or to wherever it is because they were having a problem. That does, while maybe not under ADA, it could be a national origin issue. If you're doing these broad bans that aren't really tied to anything else, somebody could say, okay, you're really just targeting Asian people, or you're really just targeting, whoever. So, that is something to consider. It just kind of, popped in my mind. These days, it seems like we're really the ones with a huge problem, and going to Arkansas isn't really going to be a national origin discrimination claim. So, is what it is.
Yeah, I think one of the earlier slides said I would look at the CDC website to see what locales are deemed high and dangerous, and if there's a travel advisory for a particular country, that would probably be justification. So I generally rely on CDC guidance on what areas are of concern, including parts of the United States, if you want to do so. So now we've got issues where people are coming back from travel or have to be quarantined. If you require employees not to work for 10 to 14 days, do they have to be paid? If there's, so the question then becomes there's nothing that mandates that they be paid, but you could allow employees to use sick leave. And if you have adopted FFCRA, that might apply for a period of quarantine. And if they exhaust paid leave benefits, can they be on unpaid leave? Sure. And there are issues between salaried and non-salaried employees, as you know. Salaried employees who work any part of a work week are entitled to be paid for the full work week. So if I'm a salaried employee and I don't have any more sick leave, and I miss 3 days of the end of my quarantine period and then come to work the last 2 days, I'm entitled to my full weekly salary to remain exempt, even though I only missed part of that week, unless it was FMLA covered, and that's an exception. But if it wasn't FMLA covered leave, then you'd have to pay them the full salary. Another law that's implicated by COVID is the National Labor Relations Act. Employees who refuse to work can refuse to work if they think their work environment is not safe. There have been a few cases like this. There's some issues in even non-union settings where employees have walked out in protest, claiming that the workplace is unsafe and that they don't have enough PPE to meet the safety standards. So remember that protected concerted activity on behalf of your employees, whether they're represented by a union or not, is protected activity, and any kind of discrimination or retaliation against an employee for protesting that or refusing to work with others in protest of working conditions would be protected under the National Labor Relations Act. Now, there are some exceptions if the safety of people are endangered, but that's a really narrow exception for a walkout based on concerted activity. Oops. Okay. Many people have been telecommuting. I think the statistics that we looked at, Joe, did you post that? Like 52% of people that have been teleworking don't want to come back to the office, I guess.
Yeah.
as SHRM study indicated. So we're looking at a time when there might be some resistance to people coming back into the workplace because they've gotten comfortable working at home.
I
On
think
the other hand,
I think our poll results showed about 70% of the people, so like 74% of the people on this seminar said that their workforces come back to in person.
oh, good, good. And I guess that then this doesn't become that big of an issue, except for those 20-some% that still have people telecommuting or want to. Our view of this is just two things about it. Telecommuting as an option, unless it's required as a reasonable accommodation by ADA, I tend to use these guidelines. Make sure the person's exempt from overtime, because it's hard to track time work for people who are not exempt. Work being more information-based than physical. Jobs that productivity can be measured more easily. Jobs that can be done alone. Obviously, if you're a supervisor and you have to interact with other people, it's harder to supervise people remotely than being present and having that kind of interaction. Although we've gotten very good at Zoom and other means of communicating. Again, the kind of jobs that work for telecommuting are those that don't require frequent supervision or input from company personnel or physical contact, and where we agree that physical presence at the work site is not an essential requirement. So general guidelines on telecommuting there. Okay, these numbers might have increased in the last week or so. This is from about a week ago, but this is the area we need to vaccinate. Healthcare people, that's about 6% of our population. Essential workers and adults 75 and older, about 20%. Those 65 to 74, and those with high risk conditions, another 47%. So we're looking at, if we get this phase of 65 and over and those at high risk vaccinated, we're going to have 67, 70 some 73% in this group vaccinated. That's high enough to generally say we're close to having herd immunity, and that's the goal. Obviously, there are some people that don't want to get vaccinated, and so one of the question is, can I require vaccination? So we talked about what's the safe thing to do when you bring people back. Can I tell everybody they need to be vaccinated? Well, under disability law, yeah. The EEOC has issued guidance that says the ADA does not, and state law would not prohibit you from requiring employees to be vaccinated to return to the workplace. There are two exceptions. One under disability law, that is a health condition that places an employee at higher risk of injury to themselves by getting the vaccine. So if I have some kind of impaired immune system, or I have a condition that reacts to some of the virus of vaccines, I would have to, as the employer, reasonably accommodate that employee who cannot take the vaccine. Likewise, if I have a religious belief that vaccines are against my deeply held personal views of spiritual nature of some kind, then my religious objection would require reasonable accommodation. Now, here's one of the difficulties. The form of reasonable accommodation for these two conditions is different. For a disability, you must make a reasonable accommodation to enable the employee to do the job. So if I have to come to work and you have a rule that says I have to be vaccinated and I can't get vaccinated because of my medical condition of one kind or another, how do you accommodate me? Well, there are other steps. So what the EEOC says is, in this case, you're looking at, does the employee present a direct threat to themselves or other people by coming into the workplace not being vaccinated? What options are there? Are there other mechanisms that you can put into place, other procedures, social distancing, mask wearing, that are adequate to ensure a safe workplace? and reduce the risk of harm to others sufficiently that they are no longer a risk to their own health, the health and safety of other people. That's going to be a back and forth with employees. Can you put them in a separate room? Can you schedule them at different hours from other employees? So the accommodation under disability law is going to require an interactive process of going back and forth with the employee to determine whether there are options to reduce the risk that this employee who cannot get vaccinated is still safe to come to work and not present a serious threat of imminent harm to other people by reporting to work, which seems likely that you'd be able to do because of the existing social distancing and PPE that's available. You can require it unless there's a disability related reason that the employee cannot get vaccinated, and then you have to accommodate. It means you might have some people vaccinated and some who are not. With religious objections, it has to be a sincerely held religious belief. I can't just walk in and say, well, my religion says I can't get vaccinated. You say, okay, what's your religion? What is the belief that you have? And basically, people can make up their own religion. It doesn't have to be an established religion. I can say that, you know, I believe in only natural foods, and I believe in the earth and all these wonderful things, and I can't take vaccines. I don't get any vaccines. Okay, that's your deeply held religious belief. Now I have to reasonably accommodate you. However, the burden of reasonable accommodation for religion is much less than the accommodation obligation under disability law. I need not engage in any accommodation that creates more than a de minimis burden on my business. And that is a fine line that generally has been said, okay, well, I'm of the opinion that probably if you have a religious objection to getting vaccinated and you have to work in my workplace with other people, I might be able to tell you, well, until you're on leave of absence until the pandemic is over. And I would probably say that employers have a lot more leeway in keeping a religious objector out of the workplace if they have a mandated vaccination policy to return to the workplace.
Yeah, I just wanted to jump in real quick with that because I saw a lot of this coming up with the flu shot this year with some of my health centers. And, you know, really, we didn't get any disability accommodations. They were all for religious reasons, and they were all over the place. You know, I know that there's a question about, are there any known religions that oppose vaccinations? That's kind of a tricky question because it depends on what's in vaccinations for like Jehovah's Witnesses. So if there's like blood particulates or, you know, different things like that, then yeah, Jehovah's Witnesses say that you shouldn't take the vaccine. But, you know, even with my Jehovah's Witnesses, when you come back and you say, okay, CDC says, here's the list of ingredients, there's nothing in there, usually they will say, okay, and they'll just take it. You know, they've been really good about it. Where we've had the most problems with this religious accommodation is normal people who I think just don't want to take it. And so they come and they do exactly like John said, and they say, oh, well, you know, I'm just really spiritual and I believe that my body is a temple and I can't put in anything that could harm it. Or, you know, God has told me that they haven't done enough research on the vaccine, so it's not safe. And then how do you deal with that? Because courts really don't want to wade into this idea of what is a religion or what is a deeply held religious belief, right? It goes back to the case with Flying Spaghetti Monster religion in Utah, where you had people putting colanders on their heads to take pictures for their driver's licenses. And the DMV said, we're not going to take your photo. And they said, no, this is a deeply held religious belief. And they litigated it and they were allowed to wear colanders on their head for the driver's license. So, you know, courts don't like getting into that because people really do believe lots of different things. And the court just doesn't want to say, okay, this is a legitimate religion. This is not a legitimate religion. So, you know, it's very, very difficult when you have people that come in and say things like that. I had multiple people say, quote a passage from the Bible that, the body is my temple and I don't do anything that could possibly harm it. And, it kind of begs the question, your knee-jerk reaction is, okay, well, do you drink? Do you, what do you do then? Like, let's pick this apart. But a court's not really going to want to get into that so much. So you have to be careful and then go back to say, okay, well, what do you want then? And then say, well, we can do that or we can't do it. It's been particularly difficult because we have been wearing masks and working the whole time and showing that appears to be a reasonable accommodation for it. So how do you get around that when they say, well, I just want to continue wearing my mask? It's a tricky thing. And I think that the employees who really don't want to take something will come up with something. They go online and they download these forms that certain places put out to give to elementary schools, and they cite provisions and laws, and people think, oh, I'll just use this. And when you look at it, it applies to elementary schools. It doesn't apply for an employer relationship. But what do you do with that? Because they still have this, that some pastor, preacher, whoever signed off on saying that they shouldn't have to take a vaccine. It's difficult to navigate. I just kind of wanted to note that it is something that comes up quite a bit. And I think that as, the COVID vaccines push harder and harder, we'll see more and more, pushback, considering I have trouble getting people to take a flu shot. They say, oh, well, I know somebody who knows somebody that was paralyzed from the waist down when they took their flu shot. What do you do? And then they tie that with some sort of spiritual belief and you're kind of stuck.
Yeah. It gets complicated, but recently I had a case involving an employee who just basically argued it's my individual freedom under the Constitution not to have to wear a mask, for example, not even a vaccination, just a mask. And we said, no, you don't have a constitutional right to work here. So you either wear a mask when you're at work or you don't work here. So there's all kinds of arguments people are making that are just specious and baseless.
Yeah.
Or they'll say, I have religious liberty. And you go, well, what is your religion? What religious belief do you have? And they can't come up with anything.
Yeah, that's the EEOC specifically mentioned that on the that recent seminar that they did, that they're not entertaining those kinds of complaints where people say, oh, it's, violating my quote unquote rights, whatever right that is. I don't have to wear a mask. They said that they're not interested in that.
Yeah, and I wanted to mention two things about accommodation under the ADA. Obviously, there are going to be people with immune disorders or some condition that gives them a greater risk of exposure to or greater risk of harm to themselves by coming into the workplace with people who could, during a pandemic, transmit the illness to them. So you're still going to have to make accommodations even after everybody's vaccinated for those people who have some underlying health condition that makes them highly susceptible to severe harm if they get the virus. So that's one thing to mention. The other is there's a number of cases and guidance from the EEOC on individuals who have mental conditions that are exacerbated during the pandemic. People with PTSD, people with obsessive compulsive disorder, other things that are triggered during this period of isolation and a period of working with other people in close quarters. Now, again, so people that have, there are certain mental conditions that, hey, I'm really good at working from home, but when I come into the workplace, I'm freaked out by having to work around other people, and their mental condition gets exacerbated by putting them back into the workplace. You're going to have to deal with those mental disabilities just like they might have a physical immune deficiency. So that's important to keep in mind in accommodating disability-related requests for accommodation, whether it be the vaccine or whether it be just generally coming back to work under new conditions. The last thing I wanted to mention about, two things I want to mention about vaccines. There is a risk, and there's kind of a dispute about this or disagreement among professionals about requiring vaccines at this stage. as an employer policy. Currently, all the vaccines that are available are authorized by the FDA under something called the emergency use authorization. It's a procedure under the FDA that authorizes the emergency use of the vaccine, and after determining that the potential benefits outweigh the risks. But it has not gone through the full FDA approval process like most of our flu shots have. So your annual flu shot gets approved through a longer series of testing and a process that doesn't require this specialty kind of approval because of the emergency nature of the pandemic. Because these vaccines have only been authorized for use under the emergency use authorization provisions, the law requires that every individual who gets the shot be advised of the risks, and they have to voluntarily agree to be vaccinated. So the federal law that authorizes the use of the vaccine basically says you can't be forced to take this vaccine. That raises a question if an employee refuses to get the vaccine and says, well, I know that I had to look at a piece of paper and it said, is this voluntary? And I don't want to take the test. I don't want it to be voluntary. If I have a choice under the law that it be voluntary or not, I'm not going to take it. So I am insisting on my legal right under the FDA emergency use authorization provisions not to take the test or not to take the vaccine. Does that objection to taking the vaccine based on a federal law create a public policy exception to the at-will doctrine that if you terminate me for not getting the vaccine, can I sue you because I was insisting on a legal right not to be vaccinated that exists under the emergency use authorization? Eventually, all these vaccines will get full approval likely. Not for a while, and not right now, not for the foreseeable future, but by probably next year or maybe even the fall, they'll get beyond the emergency use authorization, and this won't be a public policy wrongful discharge kind of question. But right now there's a question, and nobody has litigated this to my knowledge, and I've been trying to track it to find out if anybody has actually asserted this. So in states that allow employees to sue if they are terminated in violation of a public policy of the state or federal government, could they raise this as a defense, as an argument, and litigate it? Yeah, it's possible. But the question, the defense, I would say, is there a countervailing public policy that encourages vaccinations? And further, some of the commentators have said this voluntariness is only directed at the government, that the government can't insist that everybody be vaccinated under the emergency use authorization, that it's not intended to apply to private sector employers. I don't know, there's not been a definitive ruling by any court anywhere on that issue. And maybe, like Joe mentioned earlier, maybe it's permissible to require vaccines even if they have a choice whether to take it or not. The same way testing for drugs is permissible. So I'm going to require every one of my employees to get a drug test before I hire them. I'm going to require every employee to get a vaccination before I hire them. You don't have to take the drug test. And if you don't take the drug test, you don't work here. That's simple. You don't have to work here if you don't want to take the vaccine. Same principle. I'm not forcing you to take the vaccine. I'm just saying if you want to work here, you have to be vaccinated. Can I do that? I think it's a defense to a public policy wrongful discharge claim, but most employers are not going to want to take that risk, and most are probably not going to mandate the vaccine. So then, so can you just require employees to sign a statement, for example, I agree that as a condition of employment, I will get vaccinated? Maybe that might be a way of doing it. Probably the recommended way right now is to provide some incentive. And while there are federal regulations that prohibit wellness programs from offering more than a de minimis incentive, my guess is that, as Joe mentioned earlier, granting time off, giving employees paid leave under FFCRA to get vaccinated is de minimis. And if they have any negative reactions to the vaccine, paid leave for that period of time is an incentive, I would say, to get the vaccine. Can you offer more? Yeah. Can you offer, gift certificate for dinner, 25, 50 bucks? Probably. Can I offer everybody that gets a vaccine $1 an hour more per hour? Maybe not. So I think we're in incentives to get people to get the vaccine are permissible, but try not to make them so great that they look like coercion. And one of my clients, when they had mass vaccinations at their facility and encouraged employees to do so, said everybody who gets the vaccine gets to put their name in a hat, and we're going to draw for a big 55-inch color TV set. Is that de minimis? I'd say that's okay. I think people are getting creative and thinking of things to do to incentivize employees to voluntarily be vaccinated. And I think it's going to be pretty much permissible as long as it's not too coercive or draconian in its impact on those who choose not to get a vaccine. Joe, do you have anything to add to that? I thought I'd open it up on incentives.
Nope, I think that covered it pretty well.
And I think that's it for me. I know we're ending pretty much on time at 1:45.
I think we have some questions, so
okay.
I'll read them, and then we can kind of chime in however you want to do it. So I tried to answer some while we were doing this, via writing.
Right.
So here's one. So workers' comp is denying coverage due to not being able to determine exposure source. COVID being prevalent in healthcare, what could liabilities be for organizations? Is there a more specific guidance to make this determination?
I think when I went through the OSHA guidelines, I think what you want to show is that you have a policy that requires compliance with the basic mandated social distancing guidelines that CDC puts forth in the county and state guidelines. And that will be your defense to a claim that I was subjected to some kind of injury at work. I got COVID at work, and therefore I'm going to sue my employer. As I mentioned before, it depends on whether it's work related or not. But let's say an employee thinks it is, although workers' comp denies it, and then they sue you in tort, saying you created a hazardous working condition. I think your defense is always going to be, I took reasonable steps to prevent the spread of the disease in the workplace, and it's a pandemic that's outside of the workplace everywhere. And you can't hold me. There've been a couple cases that have held this, that you can't hold an employer responsible in tort for getting the disease when it's so prevalent outside of the workplace.
Okay. I think we have a couple questions that generally are, can you ask employees whether they have received the vaccine? And can you track it? These are the employees who have been vaccinated and these aren't.
Yes. Yeah. Yes. The EEOC says you can ask employees if they've been vaccinated, and you can track it internally. You can't make it public. I disagree with those people that say you can put a little badge on the people that have been vaccinated. Say, I'm a VIP. I've been a vaccine injected person, and they get to walk around without a mask and hang out with other people with badges. And those that don't have badges don't get to do that. I'm not comfortable with that. I don't think that would be appropriate, but I do think that you can ask. The problem really comes in asking somebody who says no, they haven't, and you ask them why not. That raises some issues because then they start to disclose, oh, it's my religion or it's a disability, and that might not be appropriate. So my advice is, if somebody says they've been vaccinated, great. and you can allow the social interaction that's permissible under the guidelines for those who you know have been vaccinated. And if they say, no, I haven't, I would stop there. I wouldn't ask the next question.
Yeah,
Why
and
not?
right. I know that for some of the health centers and hospitals, they were really quick to say if you've been vaccinated, you are allowed to go into the lunchroom without your mask, and you're allowed to congregate. You're allowed to travel without having to take an extra test when you get here. And they also do like little tags or badges on their stuff to say, oh, you've been vaccinated or not. While I agree with John, my specific advice was it's probably a bad idea. Maybe you can do it once CDC says it's okay and you're following guidelines, and it still kind of feels like it may be problematic. I know that people are doing it anyway and kind of ignoring our advice. So, maybe it's one of those things to kind of see what industry standard is for, if it's a health center or a hospital and they are putting tags on badges to say these people have gotten their shot, and, maybe probably okay, but, do you want to wear a sticker if you're just an office worker? Maybe a little bit different.
Yeah, I think one other thing about vaccinations is that's interesting. The EEOC has ruled that the vaccination itself is not a medical exam. So information that you've been vaccinated doesn't fall into the medical information category. However, answers that you might give as to why you're not vaccinated are inquiries into protected status. And even if the EEOC would allow it, I caution people not to ask that second follow-up question, because our state law prohibits those kind of inquiries in and of themselves, even if you don't rely on those answers to make any adverse decision. So I just really think it's inadvisable to ask a follow-up question. If somebody says they haven't been and you do have an incentive, you can certainly tell them that, well, if you do decide to get vaccinated, and we encourage it, we'll pay for your time off to get vaccinated. And if you're not feeling well after the shot, the time off, you could do that. But I just don't think it's advisable to get into the follow-up questions on why not. And that raises the other question about who gives the vaccine if you do have employees. We always have recommended that you go to a healthcare professional, because the healthcare professional has to ask those questions about, do you have any conditions? And I got my shot, and there's a whole list. If you've gotten your shot, that you got to read through a list of a page and a half of conditions as to whether you have them or not before you can get vaccinated. So I recommend that employers not try to do the shot on their own, just hire a pharmacist to come into the workplace and give shots under your direction. You could hire or you could get CVC or Longs to come in and give shots, but they would be the ones asking the questions, not the employer.
Yeah, the EEOC mentioned that they might consider that to be violating GINA too, which is something that we don't talk about a whole lot, but it's Genetic Information Non-Discrimination Act, I think. And they're saying that asking those questions or asking whether family members have certain things would be a violation of GINA, and they could prosecute or hit you with a discrimination charge because of that. So just be aware that like John said, I wouldn't want to be asking the kinds of questions that a healthcare professional must ask, because it's prohibited for us to ask it.
But you can ask, interesting enough, you can ask an employee to show you proof that they have been vaccinated if they say they were vaccinated.
Right. And I think that was one of the questions on here too. So yeah, you can ask for the vaccination card. And I think that we're going to get the vaccine passport sooner than later. Josh Green was saying that we're going to have some sort of information about that too. So
and again, they caution, don't ask follow-up questions.
Right.
If they say, well, I don't have a vaccination card or something, you don't want to go there. You don't want to ask why, because then they're going to say, well, I didn't really get the vaccine or whatever. Because it could elicit answers about disability and other things. What else? Any other questions?
Oh, so there's one that says if employees choose not to get vaccinated, can we ask employees to sign a waiver releasing our company from any liability if they contract the virus? Since we cannot determine whether they exactly contracted the virus, where they did. I'll answer that real quick because the EEOC specifically mentioned this. The EEOC said that you should not be asking anybody to sign waivers related to COVID, that they are, besides being other problems with it, they consider that they won't be enforceable anyway. So it's not really going to do you any good to have anybody sign a waiver.
Employee.
Yeah.
That now there may be a different standard for customers or guests, or you not employee related, but for people that you allow onto your premises or come into the workplace as vendors or customers, you might be able to get some kind of waiver that might be more enforceable than against your employees.
Okay. I think we answered this question about whether we can ask for a copy of a negative test result as evidence before they return to work. Yeah, the answer is yes. And then this last question is, if company has policy that no travel other than for mandated business or with approved FMLA, since we don't support travel, employees also when returning must do a quarantine. If essential frontline worker, then they will use PTO or vacation time to be out. Is that okay?
Yeah.
Okay. All right, I think that's all of the questions that I saw. Oh, there was one question in the chat about there's some problem with the union giving them a hard time about vaccines. But I think that's really an issue you're going to have to talk to the union about how you want to deal with them.
Yeah. So the like the UH app.
Yeah, that was exactly it.
Let's talk about that real briefly. So any employer that requires employees to complete these on-site questionnaires on symptoms, remember, if that's taking up more than a de minimis amount of time, you've got to compensate them for that time. So that if I have employees require them to fill out a questionnaire of 3 or 4 questions every day before they report to work, and I'm doing that outside of my punch-in or normal work hours, and I'm an hourly non-exempt employee, every day for a minute or two filling out that form adds up to 10 minutes a week at least. And 10 minutes a week times 4 weeks is 40 minutes. That's compensable time. So businesses need to think through how much time they are requiring their employees to spend completing these daily symptom checks, and maybe consider just doing it periodically or doing it once they clock in.
Okay, and I think that question too was about how can they implement some sort of consequences for refusing to use the app.
You don't let them come to work.
Yeah, and if the union has a problem with that, then I mean.
It is probably a bargainable subject matter for bargaining unit people. I mean, there are emergency exceptions to the duty to bargain, but again, I think you probably it'll notify the union that in the interest of public safety, we're requiring everybody that comes onto our property, premises, campus, school, building, whatever it is, to complete this brief symptom checklist. And if you have any of these symptoms, you're not allowed on. And you let the union know, and you say, we're willing to talk to you about this. And they say, well, we don't want that. And we said, well, we think it's necessary. Well, we don't want to do that. We want to be compensated for that. No, we don't think you need to be. Well, sooner or later, you're going to disagree, and you're just going to implement it because you're at impasse over some matter. Or you'll wind up agreeing on something. So there's a process of notifying the union and negotiating, but ultimately, I think you'll eventually be able to implement what you want to. And if not, it goes. Normally, these kind of things wind up either before an agency that determines whether you bargained in good faith and before an arbitrator as to whether you had the authority to implement those procedures under some management rights clause or language in your contract that gives you the authority to act in the event of an emergency. And I haven't seen a case yet from the NLRB that addresses this, but there are exceptions to the duty to bargain in emergency situations, and I can't imagine that a pandemic wouldn't be considered an emergency situation given the billions of dollars that we've been spending as a country on it. Oh, I did want to mention one thing. Today, the U.S. Department of Labor published a website to allow individuals to report unemployment fraud. So if you get a 1099 that says, you're getting unemployment benefits and you never apply, that somebody is using your social security number or name to try to get benefits, and you can report that to www.dol.gov/fraud. There's I forget the numbers, like $650 billion has been paid out in unemployment benefits so far. And there's a lot of fraud in states because as Hawaii, our system was outdated, wasn't prepared to handle the amount of claims coming in. And when they started processing claims, people were getting away with fraud. And that's happened all across the country. And there's discussion now about whether to nationalize unemployment processing in states, even though each state has different standards, to have some kind of uniform system of reviewing and collecting data so that this doesn't happen again. In any event, it's www.dol.gov/fraud. Thank you.
Hey, John.
Hi, Sherry.
Hi. Good
How
to
are
see
you?
you. Good.
Happy belated birthday.
Oh, thank you. Well, thank you so much for taking the time to do this. It's very informative, high level of interest. Obviously, when you look at the drop-off rate, there was hardly any. Everyone almost stayed on the entire time. So wealth of information. So thanks again for that. To our participants, as a reminder, this session is recorded and the link will be provided to you in the next couple of days. So you can review it again because there's some wealth of information that we'll need to incorporate in our own workplace as well. So mahalo to all of you, and stay tuned for more information on our 2021 Employment Law Seminar, so far being held at the Sheraton Waikiki on Friday, August 27th. So thanks again, and hope to see you soon, hopefully in person, if not virtual. Thanks, John. Thanks, Joseph.
Thanks, Joe. Thanks, Sherry. We'll see you soon.
Yep.
Thanks, everyone.
Bye-bye.